Hey, everybody, and welcome back to the Legal Weekly Wine. It is the first full week in February 2024, and what a day in February 6th, Tuesday, 2024. It is Wednesday today. We could not help but talk about this monumental day. We have got a ruling from the U.S. Circuit Court of Appeals for D.C. against Trump in the presidential immunity case. We have a jury verdict of 4 counts of involuntary manslaughter against the mother of the Michigan shooter, Crumbley. We also have the failed impeachment for Mayorkas in Congress, as well as, a couple of other things along the way. We also have the discussion about Fani Willis, the information that's coming out now about her, as well as possible perjury in the civil fraud trial against Trump. So it is a packed week. Join us for this full conversation. We're going to hit all of it. If you don't hear one part of the conversation, skip ahead to the others. We think you'll find something you like and enjoy. And speaking of enjoy, if you're enjoying our program, please hit like and subscribe so that you can find our next ones and others can enjoy the program too. I'm Virginia Tirani. I'm with Tirani Law LLC, because you never need a lawyer till you do. And we are also with the Law Unscripted. That is the company that is hosting the Legal Weekly Wine. It's an education company for law students, undergrad students, and those looking to learn about the law. We have this podcast, another free podcast, and law exam and bar exam help and preparation. But that concludes me. We've got Dr. John Weil joining us. He's the Dean of the Middle Tennessee State University Honors College. He's also an expert on the Constitution, the amending process, and constitutional law. Welcome back.
Good to be here.
And Chelsea Rogers, she's an attorney with Tirani Law as well. And she's also a member of the Law Unscripted, very invaluable for all of her resources. She is up to date on all of the facts and the legal analysis of these cases, especially with the trial of the Michigan shooter today. So we are looking forward to hearing all of your expertise. And let's get to the wine and then to our hot topics, because it is the Legal Weekly Wine. Anybody have something to drink today?
H2O.
Woohoo! All right, your H2O. I really keep thinking that there's the water into wine happening every week that we just haven't caught on to yet.
Hey, what? If we could do that, we would get many more listeners.
Well, that's true. Many more listeners, a lot more money. See if you can work on that. Maybe we can get a priest in for the Eucharist. Chelsea, on that note, what are you drinking today?
Same as always, my classic boxed wine. As always, I'm back here with it.
Fantastic. Well, I've got a different one today. We haven't done many Côte de Rhône. We usually do a lot more of the sweeter wines, but I actually really like Côte de Rhône. It's a nice red wine. It is a French wine. It is from that area. Domaine de Cristia, Côte de Rhône. However great that pronunciation is or not. It's a 2021. I will put a description in and where to find it in the description for this podcast. So that's what I am drinking. I am also, because I haven't eaten very much today and thought, well, wine and chocolate go together, I am doing a Hershey bar. This is not a paid advertisement. It's just simply a good Hershey bar with the chocolate. So wine and chocolate it is for me. Cheers, everybody.
Cheers.
Oh, that goes down so well. It's so light. That's really nice, Côte de Rhône. So, gonna eat some chocolate. And now what we're gonna do is let's start with the presidential immunity. This was an extremely significant ruling that everybody has been waiting for. We've been on our seats. We've made some predictions about it. We've talked about the presidential immunity and how far it goes, but let's talk about the ruling by the U.S. District Court of Appeals, the Circuit Court of Appeals for D.C., and how many judges, why there were only 3, what the actual decision was, what the implications are, what happens next. And Dr. Weil, I know you have a different take that I don't think many, if any, people have really picked up on with the decision. So we're going to talk about that too. But let's start, Dr. Weil, if you can give us the initial description of who made the decision, how many, why it was so few, and what the actual decision is.
Okay. Well, this is actually a follow-up case. We've had a district court decision that was stayed, as I understand it.
Correct.
I mean, she made the decision, and then she said, "I'm not actually going to apply it until till it's going on appeal."
And this was
So the
Judge
district
Chutkin.
decision basically decided. Well, I don't. Here's where I would need to go back and look. I don't know if it was a sitting president or a former president, but whatever it was, Trump did not have immunity against criminal prosecution. This case, so typically a case, if it starts in a federal court, you have your district court, you have your circuit court, and then you have your Supreme Court.
Correct.
So it's now and in your circuit court decisions, typically they are 3-judge courts. You have a panel that's much larger than that, but to get to all the work, they divide them into 3 groups of 3, and they do the decisions.
So this isn't unusual that it's only 3 judges. It's not
unusual at all, no. I think it's probably actually fairly normative. If it's a really consequential case, but even then, I think that what would typically happen is if you got a 3-court judge decision, they could then ask to have an en banc, or everybody on the circuit listen. And that's a possibility here, but those possibilities are more likely in a case where you have a split decision,
right,
or where you have a decision at the circuit court that differs from that of the lower court. And this is a per curium decision. We've talked about that before.
But what does that mean?
Well, right, curia is a group, but in this case, it means you have a decision that is agreed to by all 3 of the justices, but not or
it's
judges,
unanimous.
I guess I should say. They're not Supreme Court. All 3 judges, one of whom was a George Bush appointee, maybe H.W. Bush appointee.
So Republican.
Pardon?
Republican.
Right, and two Democrats. So far you've had 4 judges who have all basically said the same thing. So the most logical thing that would happen now would be that it would be appealed to the Supreme Court. Now, the Supreme Court doesn't have to take it.
Right.
If it doesn't take it, it leaves the decision in place as valid law. It wouldn't be quite the same status as if the Supreme Court took it and then affirmed it. On the other hand, in terms of Jack Smith, he probably hopes the court just leaves it because that means he can proceed ahead.
Right. There's no more delays in his case.
That's right. And essentially, I mean, at issue is well, and here's where you mentioned I had sort of an unusual take on it. I cannot tell whether the decision applies to a sitting president or not.
Or whether it waits until he's out of the presidency.
Right. I mean, it's clear that it applies to an ex-president. And the logic, I think, is impeccable. The president argues that, or Trump, former president, Trump says, well, if I had to worry about criminal prosecution, I wouldn't want to do anything out of fear. The court says, well, if there's one thing maybe you should be fearful of doing, it's disobeying the law.
Right.
You weren't elected to violate the law. You're elected to enforce the law. And as we had in our prior pre-discussion on this, the court relies fairly strongly on separation of powers.
Right.
That, there is no presidential power to disobey the law. Now, some presidents have done it, sometimes for valid, and sometimes the presidents have acted in the absence of law. But here you have what appears to be a president acting contrary to law instead of, and at the most basic level, you have a president who is disputing,
right?
He's intervening to try to keep himself in office even after his vice president and courts and everyone else has told him that he has lost. So it's a fairly fundamental argument that's happening here.
Yeah, and I want to pick up on some of the things that you're saying because there's some great quotes that you're
Yeah.
explaining. And I want to read some. Normally, we don't always read from the decisions, but this one I think is really important. So you were talking about the branches of government and the quotes from the decision. It says, at bottom, former President Trump's stance would collapse our system of separated powers. That's what you were talking about. By placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that, as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Now, that's where your issue comes in, Dr. Weil, of where it says former occupants, not current. So does this apply?
Although they say former, they do cite a case, probably more than one, but they cite cases that applied to sitting presidents, one of which is the steel seizure case.
Oh,
so
sure.
Truman said, I'm going to seize the steel mills to stop a strike during the Korean War. And the court says, unfortunately, you're acting under congressional authority, and that authority did not give you the power to do this.
Right.
So I think the logic actually applies to both sitting and former presidents, but most of the time they're fairly focused. And this is not unusual that a court will, let's not say more than what let's stick to the facts at hand. Let's specifically address that. It's very focused on this particular case.
Right. And one of the reasons I've heard the concepts or the arguments for this case as why the Supreme Court wouldn't take it. And it's one of the things that you said, Dr. Weil, of there's nothing at issue. 4 judges have now decided the same thing. There's not a split decision. There's nothing left to decide. But I think there may be in this case with what you're saying, because here's another quote that goes exactly to the sitting president versus the former president. It says, for the purpose of the criminal case, former President Trump has become citizen Trump, with all of the defenses of any other criminal defendant, but any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So that's where we're getting into this issue of, well, if he murdered somebody while he was a president, is he now completely immune until he gets out? Is the only remedy impeachment? And is that enough? Chelsea, what do you think?
I actually thought that was funny. I saw some commentary on that the argument they're making is that Joe Biden could go find Trump in D.C. and kill him, and he would be immune from prosecution from it. Like, that is what the argument being made is, right?
Oh, I so missed that one.
Oh, I'm not sure who said it or if it was a news reporter. I just saw like the headline of that, and I thought it was a great way to point out sort of the absurdity of it, right? To me, as Dr. Weil has said, I think that the president should be upholding the laws. We shouldn't be worrying about having to have a federal indictment of a president. But since we are, I think they should be held to the same standards as everyone else.
Yeah.
You remember in the lower court, the question, and was it Tan, the judge?
I don't remember.
One of the 3 judges, I may have the name wrong, but one of the 3 judges asked, does this mean that you could send a president could send SEAL Team 6
That's right.
to assassinate someone and they would be beyond the law?
Right. And the lawyer said yes.
Yes. Yeah. I mean, it really, Trump did not make a nuanced argument. He went, or his
full
attorney,
out,
as we would say in the South, whole hog. I mean, no nuance at all. We're asking for complete immunity. And again, when it comes to civil immunity, it makes some sense that, president has to make a lot of decisions if it's within the confines of his authority. But, what if he, enacts retribution on a family member or, somebody doesn't like,
Right. Are we North Korea?
One thing that bothers me about that second quotation is Trump is now citizen Trump.
Right.
Right.
In my judgment, Biden is still citizen Biden. He may be President Biden and he may have certain privileges there, but you're still a citizen. You are still subject, I hope, to some kind of boundaries.
Right. And this goes right to, here's another quote that goes right to that. And Chelsea, your comment as well. This says, it would be a striking paradox if the president, who alone is vested with the constitutional duty to, quote, take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. So that goes to those. We cannot accept, here's another, we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and to have their votes counted.
I mean, I completely agree. It's the idea that, like, it's a president, not a king, right? Like, these rules are supposed to be for everybody.
Yes. Yeah.
We're not saying that, you're president, so now, like you said, just open season. You have no checks on your power. That's not what this is supposed to be, right?
Right. And I think that goes back to the earlier comment of theirs of there's three branches of government. We have separation of powers for the common phrase we use, checks and balances. I mean, we learned this in middle school and high school. The whole purpose of our government is to provide checks and balances against the other powers. So this is, here's the, Biden kind of thing, is it says Trump's reading of the Constitution, quote, would leave a president free to commit all manner of crimes with impunity so long as he is not impeached and convicted. So that goes more to the sitting president.
Yeah, Trump had what most people consider a very novel legal argument, which was, the Constitution says impeachment in the United States is not a criminal penalty. It's a removal from office and possibly a barring from future office, but it doesn't take your property. It doesn't put you in jail. It doesn't kill you. So Trump's reading, or Trump's lawyer's reading of the impeachment clause is, impeachment says, once, if you've been impeached and removed from office, this doesn't absolve you from future criminal liability.
Right.
And Trump says this means if you're impeached and not convicted, that you
can't be tried.
Are exempt.
Yeah,
it
you're
was a novel
found not
argument.
Guilty.
It's logically, all judges who have looked at this basically have said this is a logical fallacy.
Right.
This sentence is referring not to both cases, but to the case of whether you've been removed from office, what can then happen to you.
Right.
But it's one of those, it needed to be nipped in the bud.
Yeah. Well, the other interesting piece of it, and it's going to be a jury trial, and ultimately the decision of whether he committed crimes with regard to January 6th will be up to a jury, a 12-member jury. However, in this decision, the judges continue to seem to express the idea of if these facts are true, then he is guilty of crimes. He has violated the constitutional rights, like we were reading, of the citizens to vote and to have their vote counted. So in my mind, it almost makes it harder to find an impartial jury.
Yeah.
If these judges have already decided essentially that he's guilty, how are you going to find a jury in D.C. that hasn't known this decision? I'm not, you wouldn't want me on the
Nobody's
jury.
going to read it but the three of us and a couple law professors.
Okay, never mind. The jury will be fine.
I was going to say, honestly.
And if they are, distract them with Taylor Swift or something like that, and it'll be fine.
Chelsea, what were you saying?
No, I was just going to say, if we're going to have, pull a jury out of anywhere, people who understand, I heard a fact once, have no idea if it's true, but that DC has the most lawyers per capita of anywhere else in the United States. I believe it. It seems anecdotally true. Have no idea if it's actually true. But the only other thing I was going to say is I think it's silly, this whole conversation around impeachment versus being able to be federally indicted. Is like, we're talking about different burdens of proof, different standards, different rules of evidence, like all of that. I don't think it's a comparable comparison, even just on the practical part of like what happens, the procedural of an impeachment is so vastly different than what a criminal trial would be that I don't really think there's much to stand on there.
That's a great point. And I'm sorry, my dog is asking for attention. You can't see her, but we all support dogs here. And I'm going to pet my little doggy. So that's a good transition time. We're going to go from the presidential immunity case to the other significant decision on February 6th. And Chelsea, we're going to have you give us a rundown of what's happened here. This is the Crumbley case in Michigan. Tell us what it was about, what the ideas behind it was. This was a jury trial, a criminal jury trial, and then what the decision was. And then we're going to talk about the implications.
Yeah, and I know you guys talked about it a couple weeks ago, so I'll keep it brief. But the idea is that back in 2021, Ethan Crumbley was a school shooter. He's a 15-year-old, and for the first time in American history, both of his parents have been charged with involuntary manslaughter. So his mother's trial was first, and that has just concluded, and the jury found that she was guilty on 4 counts of involuntary manslaughter, which I didn't know how the jury was going to decide. I had really 50-50 predictions because It was this new approach to prosecution, how people would respond to that. But what is also interesting,
it was the first time a shooter's parents have been charged in all of American history.
Right. And I think it was interesting that they also decided to charge them with involuntary manslaughter, not something like conspiracy, aiding and abetting, something like that. But involuntary manslaughter, and she was convicted of all 4 counts. So she will be sentenced, I think it's in 2 weeks. And it's about 2 weeks, and she's looking at up to 15 years.
Per charge.
Per charge, exactly. Which, that's a lot of years.
It is.
But what is also interesting, and I can't wait to talk about this, is that we have the jury foreperson doing the rounds on the local morning shows, right?
She's already talking.
Yes. Which I was like, I'm glad she's talking. I'm interested. I want to know. But also, I think there's some ethical things that we could ponder about jury members, speaking to the press afterwards. And I would love to hear what you guys think about it. She got on and said what was the most convincing piece of evidence to her was that the mother was the last adult, who was in control of the gun, and that really sold her. And she said a couple of the other pieces of evidence that really impacted them and the rest of the jury were his notebooks and his writings and drawings and that type of thing.
Yeah, let's talk about those writings and journals, because I think with the three of us speaking before this, as attorneys and as a constitutional law scholar, and someone who's extremely familiar with the presentation of evidence and the rules of evidence, I was shocked. And I think all three of us were, but Chelsea, I want you to speak on this too. I do not know in an evidentiary basis how those journals got in, because these were journals not of Miss Crumbley. These were of her son, and her son did not testify. So in my mind, this is classic hearsay of information, information submitted for the truth of the matter that was communicated outside of the jury, of the presence of the jury, outside of the court. And how did they get it in? And why did did the other side object? Why was it submitted? Because it clearly was impactful, where he's writing in his journal, my parents won't get me help. I need mental health. Nobody will help me. I want to shoot up the school. I just got a gun. I'm going to go shoot up this school. Yeah. So this clearly was, as you're saying, impactful for the jury, which it would be. But how in the world did it get in, and why would it?
And to be clear here, the significance of hearsay is you can't cross-examine someone who isn't there.
Right.
And we know in the media something that the jury did not know, which is that apparently the son has told a psychiatrist that he's lied.
He made it all up.
Some of this stuff is not true. So if I were an attorney, I would be chomping at the bit to appeal this case. And, I've had reservations from the beginning. I thought, now, I think the mother made a mistake when she said she'd not do anything differently. But when I heard her testimony, I thought it was a giant fishing expedition, and
By
I
the
was
crossing
shouting
attorney.
into the radio, relevance, relevance, relevance.
Yeah.
She goes and plays with horses, and she has an extramarital affair, and she does all of this. She's
What was the
she's not
use?
running for Parent of the Year award. The
Right.
question is, was she directly culpable for what her son did? And I do trust. I mean, I have implicit faith in jurors, and I'm not doubting that they made the best decision they could, and it might stand up. But there are some bases here. I think that one could make a good appeal.
I think the two pieces of appeal, and Chelsea, I'm going to get your opinion on this. I think the two possible bases for appeal, and I didn't watch it closely enough to know whether the defense attorneys objected. Did they actually object to this fishing expedition of, did you have an affair? Like, what in the world does that matter? It seems more prejudicial than probative.
Yes.
So did they actually object and preserve the record for appeal? And if they didn't, so if they did preserve the record, I think there's a great case to be made that this evidence shouldn't have come in. But if they didn't preserve the record, quite frankly, I think there's a great appeal of, what's the ineffective assistance of counsel through Strickland versus Washington. But what do you think?
So I didn't actually see whether or not they objected, but I do. If I'm remembering correctly, there were lots of hearings, evidentiary hearings before the trial even started. So I'm assuming that that's when things like this, or obviously not the cross-examination, but the journal sort of things came in. The only thing I can think of argument how to get that in. Now, the testimony about her extramarital affair, I have no idea why that line of questioning.
Random.
So random. But the
Just
journal, this is off the top.
Character.
Yeah. And I'm like, that to me is not the relevant issue. Her faithfulness in her marriage is not my business, is not relevant. The only thing I can think about the journal is that it wasn't brought in to say, oh, all of these things are true. It was brought in to say what she knew at the time, that she had access to the information, goes to her state of mind, sort of her mental culpability. But I think that's a kind of a stretch.
Yeah. And she denied it. She actually said, I didn't see this journal. I had no knowledge of this journal. I didn't read the journal. You're telling me what it is, but I'd never seen it before, which makes sense. Teenagers hide their journals. It's not like I would, no offense, Dad, but it's not like I would have shown you my journal.
Yeah.
I mean, kids just don't do that.
I trust you enough to believe that it would have been boring to read your journal.
Honestly, it probably would have been. The couple times I tried to write it just seems so, such an onerous, offering. Is like, oh my gosh, I'm just going to write about my day. And today I went to English class. It really would have. As much as I'm very good at many things, I am not the most interesting person. Personally, I am quite boring. So
I don't think that's true at all.
You're drinking the wrong thing, right? Isn't it the most interesting man in the world, at least, drinks something other than wine? So.
We'll have to do a special episode that's just tequila shots, and we'll see how that goes.
Oh my gosh. Well, you were talking earlier, what is it? Drunk History you were mentioning?
Yes, which is a podcast I love, but it's when they have people come on to the podcast and get fairly inebriated and then tell historical events. And it is the most entertaining way to learn history that I have ever seen. It's hysterical.
And then we were talking, so it's so close to Valentine's. And Dr. Val, you may not be familiar with this because you joined us starting in the summer. But it was when everybody go back and watch it. It was last Valentine's Day. I think it was actually on Valentine's or the day before or after, whatever it was. And we were drinking cherry wine. From Mariah Vineyards. It was from Manassas, Virginia, and we did not realize how much alcohol the content was. And it was so good, and we were drinking it like juice.
Sweet, and you could just keep chugging it back.
Oh my gosh, and it was so good. So we had multiple, we normally only do one glass of wine during the show, but we did multiple glasses. And by the end, honestly, it was the one episode where we were drunk. So if you want that it's the only time, and it was honestly an accident, but it was quite a funny accident. So if you want some entertainment,
watching it back.
Anywho, so we digress. Okay, so there's that decision. I do think it will be appealed. I think it has to be.
I think so. And it's interesting what it will be for her husband. So the father is also scheduled to stand
That's right.
trial. And that will be starting, I believe, in April. Correct me if I'm wrong. But I think it was interesting to me that the jury foreperson in this case said the fact that the mother was the last adult with control of the gun was really impactful for her. Oh, goodness.
Your dog.
My dog is making lots of noise. I'm so sorry.
It's quite all right. But I agree with you. And honestly, I think if I were the defense attorney for the father, I think I wouldn't have him plead, even though the mother was convicted. I think I would go through with a trial with another jury in hopes that they would find him not guilty so that, the mother can continue her appeal. I don't know that it's going to stand up. I think the best decision legally, without being his counsel and without knowing all of the facts, as an attorney looking at it from the outside, it seems like it would be his best bet to do his own trial. But who knows what will happen. And I think it was most interesting to me that she continued to say during the trial, I didn't have control or possession of the gun. It was in a safe. Right. My husband had the key. He had access to it. I don't know what happened to it. I don't know how my son got into it. So she was placing blame on the husband as to however he got the gun.
Yeah, and he was the one who actually purchased it. Like it was his purchase. So I think that there's going to be some interesting back and forth on what, and I think it just comes down to what the jury finds to be impactful. And so this jury found that she apparently was the last adult in control of the gun impactful. Maybe the next jury doesn't care. They care who bought it, or they care many other facts that were relevant.
Right. Okay, so next, let's go to the impeachment, because this was the same day. So we have a third huge legal issue happening on February 6th of 2024. Dr. Vial, I'm going to go back to you with your information and knowledge on impeachment. What happened with Mayorkas?
Well, it was a silly impeachment to begin with. He is not, you can disagree with his policy. You can certainly disagree with Biden's policy. He's not a decision maker as such. I mean, he's there to implement what the president tells him to do. Hasn't committed bribery or treason or high crimes or misdemeanors. Right. Republicans thought they had the vote. They had counted, but they had not counted on one Democratic congressman being wheeled in from a hospital room, and it was close enough that made a difference.
And he was quite determined. I mean, it speaks that action by itself is
very symbolic.
Very. That's the best word for it. Symbolic.
The caution here is they'll probably bring it up again.
Right.
Probably have another vote. They know, so much of politics has become showmanship. The general rule is if you constantly see somebody on television who's a legislator, they're probably not doing their job. They're a show horse. They're not interested in the public good. They're interested in their own, propelling themselves. So it's sort of a sad thing. It's predictable. I mean, if the House does. And we've talked about this before, that in my judgment, if I were to revise the Constitution, I'd probably set the bar higher for the House and lower for the Senate.
Oh, interesting. That's
right.
You should
have to have a 60% to impeach and maybe a 60% rather than a 2/3 majority to convict.
Through the Senate.
But it's not particularly, with the Senate as it is now, they're not going to vote. Even if they go through all the motions of having the hearing and whatever, they're not ultimately going to convict on impeachment. So,
and let's go back to some facts. Dr. Vial, for those who are listening who don't know, who is Mayorkas and what was the impeachment? What was the impeachment claim and what was the ultimate vote, if you know?
They fell one or two shy. I do not have the vote. I mean, he's the person in charge, is the agency that deals with immigration matters. So Mayorkas is being blamed for genuine problems at the border. And, what's fascinating is we actually had another vote last night. since last week, we've had a compromise. We've
with
had
the border deal.
what most people think is a much stronger set of border regulations, about to be adopted. And it looks like the consensus has fallen through for that. And so we're sort of, and it appears as though Trump's intervention has been consequential here.
Right.
It appears, and this is going to sound partisan, but I think that it's accurate. It appears as though Trump would rather have an issue than get legislation adopted that might take care of it. If he can go into this fall and we still have a border crisis,
and he's going to take
then
care of
he
it.
can blame Biden, even though one could say that, well, the real problem is when we get legislation, Congress won't adopt it.
Right.
So it's a pretty sad situation, actually.
Okay. So that happened yesterday as well. Dr. Vial, what else were you
Well,
wanting to say?
we need to talk about the decision that may or may not, before this broadcast is out, we won't have a decision, but we'll have the arguments.
Yes, let's do this.
And,
This is the Supreme Court
on
case.
Thursday, there is a case as to whether Colorado and or other states can exclude Donald Trump from the ballot for engaging or aiding in an insurrection.
And this is the 14th Amendment issue.
Yeah, 14th Amendment, Section 3, which was primarily was immediately designed to deal with those who had aided the Confederacy and then were trying to get their offices back, particularly in the South. And I have something to recommend for viewers.
Please.
And I think they can find it on their own because I was able to do so, and I'm not that adept at computers. But I found a set of articles from something called Public Discourse. It's a journal of the Witherspoon Institute. And there are two articles. One is by, and I'm assuming they're both, I know who the one is and I don't know the other, but I'm assuming they're both very erudite. And I'm assuming that he's a constitutional scholar. Matthew Frank, Franck.
Okay.
Called Is Donald Trump Disqualified from the Presidency? And it was published on January the 11th of this year. And he makes a very good case that he is disqualified, that he did, in fact, he got a fair hearing before the Colorado court. They decided he engaged in insurrection. They have every right to keep him off the ballot.
Sure.
And then there's an answer a week later by Michael McConnell, who I do know. He's a former federal judge and a law professor, very erudite.
Tell us
he
what
has a
erudite
response
means.
to Matthew Frank. This is January the 18th in the same magazine, Public Discourse. So, and he makes, they both make some very good points. One of the ones that I really like that McConnell makes is he says he distinguishes between a riot and an insurrection.
Oh, interesting.
Doesn't favor the riot, but he says there's an awfully big difference between a group of people, for 3 hours engaging in destructive behavior and the Civil War.
Oh, interesting.
Or, a long attempt to, set up a rival government and all this stuff. And I think it's a pretty interesting argument. And I've also read another argument since that I think could be an escape for the current court, which is to make this a states' rights issue. Say that each state makes its own determination as to who's going to be on its ballot.
Right.
And assuming they're not, doing it in a fashion that would violate, anti-discrimination provisions related to gender or race or something like that, the court ought to just say every state has the right to determine who's going to be on their own ballot. The other thing that's fascinating about this case is there a distinction between keeping somebody from being on the ballot and excluding someone who's been elected to office. And frankly, I have thought that was sort of a specious distinction, but McConnell's argument has at least caused me to second guess it, because he says, if you look at the 14th Amendment, Congress does have a right to waive this requirement. They can give a pardon. So if Trump were to be reelected and Congress decided, well, the people have spoken, we want to do the will of the people, they could effectively give him an exoneration. My problem with it is I'd rather take care of it at the front end.
Right.
You know, I think the people, you'd be less likely to have riots in the street if you excluded somebody from the ballot
versus if you take
waited
them
till
out.
they were elected and then tried to deny them office. But it's going to be a fascinating case.
Okay, now Chelsea and I have been eyeballing each other.
Yeah, go ahead.
We've got to know and explain to others, because I think I might know the definitions, but I'm not going to embarrass myself. Start with specious, the definition of specious. Because
just illogical, a bad argument. Yeah.
Okay.
I'm sorry. Professor speak.
yes. This doctorate and professor is coming out here.
I'm sorry about that. Okay.
No, it's good. So let's learn another word you've used several times, and we've eyeballed each other about, is erudite. What does that mean?
Oh, that's a compliment.
Okay.
People who use words like specious are very erudite. Okay, they have a good vocabulary. They're very thoughtful, that sort of thing. Okay, sorry about that. Listening audience, I'm sorry.
No, it's great. It's great to learn some more vocabulary, and maybe some high school students listening can increase their SAT.
Probably erudite. I may have not quite pronounced erudite, perhaps, or something like that. Yeah.
Okay. Spelling bees, SATs.
Don't judge me on my spelling, please.
Oh my goodness,
I need
will
a no
never
judgment
judge.
zone here.
Between spelling, basic addition and subtraction, and fractions, I can do calculus.
That makes one of us. That makes one of us.
Yeah,
to be clear.
Count me out.
Yeah, I'm advanced in English. I have so many good qualities, but I tell you, the absolute basics elude me, which is why we have, Chelsea and I have an actual bookkeeper in our office who makes sure that I don't write checks for 10 cents less than my client should be paid. But
if it's any consolation, your mother tried to file a report last week that listed the value of something that was supposed to be 600,000 as 600.
Oh,
before we caught it. So.
Now I hear civil fraud case coming, like Donald Trump. Is this a different valuation?
Yes.
Okay,
completely innocent in this case.
Absolutely. With Linda Vial, it definitely is. For those of you who don't know her, she is an absolute saint. And
has to be.
Right to live with you.
It's her environment. I made her what she is.
I can speak to that. Okay, so let's go to someone who is not quite so saintly. Let's talk about Fani Willis. Chelsea, and I think you and I are not as up to date on that. But if you are, please tell me so we can go to you. Otherwise, I'm going to default to Dr. Vial in this one.
Let Dr. Vial take it away.
Okay.
Go for it.
Well, and I think what happened is I think this slipped between our shows.
It did.
You remember several weeks back, one of Trump's defendants one of the defendants in the Georgia racketeering case against Trump and co-conspirators or co-racketeers, whatever the term would be. One of them alleged that there was an affair happening between Fani Willis, the chief prosecutor, and one of the others, and his name escapes me right at the moment, but one of the people that he's hired.
Right, the special one appointed.
And then there were receipts apparently produced, and I'm not sure how they got them, but indicating that this person she had hired at what they claim was a large salary had actually bought tickets for them to go on a trip together.
Vacation.
And implication of, apparently there is a relationship. And, it looked like this could derail the case. I don't think it's going to. Willis has, now, at first, she didn't do very much. She basically kept silent.
Right.
But she has since filed 140, maybe 173 page document,
Wow.
most of which, by the way, is appendices. But essentially, she says, yes, I'm in a romantic relationship with somebody that I've hired. She claims she was not in this relationship when she hired him.
Oh, interesting.
She says that, and all of this is, it's an affidavit, so it's given, as I understand it, under oath. I mean,
signed under oath, yes.
Yeah. So she further says, yes, I'm paying him more than the others, but that's because the others are in firms that support public service, and they are paying part of the bill, whereas for him, and as I understand it, he had actually been in 3 different quasi-judicial or judicial positions that he had to give up in order to take on this job.
Gotcha.
And then she further says, that the idea that he's not qualified overlooks, yes, he hasn't been a prosecutor before, but he's been a judge, he's done this and he's done that. And in my judgment, and again, I'm only seeing one side, but I mean, what we had before is we had a sort of a salacious allegation that, this guy's in it for the money, he's in it, because of romantic involvement.
They're colluding.
Right. And she's basically saying, yes, we do have a personal relationship, but that doesn't affect his pay. And in a sense, it's all irrelevant to whether the people they're prosecuting are engaged in racketeering. It would be like saying, well, Virginia Tirani, she's in this case, but I understand that she was online and drank too much cherry Kool-Aid or cherry wine or whatever it was on a Valentine's Day. What's the relevance of that to the particular case that you're bringing? So I think my judgment on reading, and I didn't read all the appendices, but on reading it it looks like there was more smoke in this case than there was fire. And I could be mistaken. And if I am, I think probably the worst outcome from the prosecutor's standpoint would be maybe they'd appoint somebody in her place, or the sub prosecutors, and that might cause some delay, but probably would not not affect the general outcome. And I could be wrong on that, but that's what I think is going to happen.
Yeah, Chelsea, as an attorney, let's get your thoughts on it. I love the opinions of Dr. Weil, and I think they're absolutely valid, and I agree with some of them. But I want to see your take. As an attorney, do you think there are implications of this affair to the actual case that's been brought? What do you think could happen or should happen because of these allegations and her admissions?
I think this is this weird gray area, right? And I think we've talked about it slightly before, of that even if something is not actually happening, there is no actual collusion, it doesn't actually impact the case. We're just going to take the assumption that they're behaving as they should, aside from, having this relationship. It still looks bad, right? And I think that a lot of the way we operate, as, being in the legal system is because people trust these systems, right? And so I think when things like this happen, even if there's no actual wrongdoing, like that appearance of impropriety, like weakens people's trust in systems, which makes them ineffective. And I think that kind of thing should be avoided. I would wonder what the Professional Ethics Board in her state would have to say about this.
It's so unfortunate.
I kind of agree that there's more smoke than fire. I don't really think the actual case has a lot, but I do think it brings up interesting questions of what is unethical in systems like that. Is it unethical that wasn't, that it's even happening, that it wasn't notated before, how does that work? And I think that raises a lot of questions for that, but I really, in my heart of hearts, don't believe they are doing anything wrong with this case, but I do think the other attorney was smart to bring it up.
Absolutely. And I would have too.
Yeah.
As a Trump attorney in that case, I absolutely would have gone after it. I agree that it's important. I agree that it's potentially unethical. I believe that there's potential implications for the case. Ultimately, I agree. I think that she should be replaced.
Yeah.
I don't think she did anything wrong with the case, but I don't think that matters. I don't
think it matters either, right? The focus has turned from the actual issue. Like if your personal life then becomes more distracting than what you're working on, take a step back.
And am I right? There was a hearing scheduled.
I think that's right.
About this. And I believe that she is saying, here's your affidavit. Here's all the evidence that you have. I don't think you need a hearing now. And so that may give us, of course, that's what you would say in that case. The one other thing that she claims is she says, yes, he did in fact buy her tickets, but when they went places that they split the bill.
Right.
And I mean, you could easily see one of them paying for the motel and the other paying for the plane or
right.
or the like. So I don't, I think if there was any indication that he's being particularly enriched by this particular case, but Chelsea has a point that would be especially relevant if this were a case involving the judge.
Absolutely.
That would be especially, judges have to not only, we talked about this before, right?
Yeah.
It's the very appearance of impropriety. And I think again, to go to smoke and fire, I think it's more appearance than reality.
Yeah.
I don't know enough about, the ethics of lawyers here to know for sure whether, but I think she made it as good a case as one could make, just reading her brief. And, maybe there'll be a counter brief that'll convince me otherwise.
Legally, it seems sound. I think legally and with the case, she did the appropriate thing. Personally, right. I think it was an extremely poor decision, especially when you're going to go after Trump.
Yeah, when she ran for office, she had said, I'm not going to use my employees as a dating pool.
Yeah. So, yeah,
makes
unfortunate
decision.
Desperate. It does. Oh my goodness. So there are so many other topics we can talk about. Those are the biggest, but I don't want to end without talking about the books. Dr. Vial, I know you've brought a couple. It's important to us to pass those along and those recommendations. Which ones do you think that we should be reading this week?
Well, I'm going to give you one that changed my mind on something. And it is by, let's see what his title is. He is a member, John Ragosta, a historian at the Robert Smith International Center for Jefferson Studies at Monticello. That sounds
nice. Good. Wow.
So it is a book, let's see, for the people. I'm sorry.
We can put it close to your chest. There we go.
There we go. For the people, for the country, Patrick Henry's final political battle. Now,
one of the founders of our country.
Pardon?
One of the founders of our country.
That's right. I have never been when I was in school, I memorized part of his speech. He's known for his speeches.
Yes.
I've always had the notion he was something of a prodigy, and he literally spent like 6 weeks studying for the law. And then he went and get certified. And most of them said, well, you really haven't studied hard enough, but you sure are smart. And they gave him his law license. And he had a reputation when he was governor and legislator that he would always leave early. And his opponents sometimes gained on him because they knew if they just waited till he left for home, they could do their own thing. But this is it's a very fascinating, Patrick Henry was what's known as an anti-federalist. He thought when the new Constitution was adopted, he thought that it gave too much power to the national government. He was very concerned about the necessary and proper clause and the like.
Right.
But toward the end of his life, he was asked by George Washington to run for office. I believe it was the Virginia legislature. Basically, Washington was on the wrong side, perhaps. Washington was favoring the Alien and Sedition laws, which the the Federalist Party had adopted, basically to squelch Democratic Republicans, and that was a bad law. But it was done for good reasons, which was there was great concern that we were about to go to war with France, and that if we did so, some of the people in America would actually be fighting for France rather than for our side.
Right.
But this makes an argument, which I think is very much needed right now, that the beauty of Patrick Henry, and Henry made some outrageous accusations against the new Constitution.
Oh, interesting.
I won't use the language that he used, but one of it was that the Constitution is going to be adopted. They're going to free the slaves. Totally specious argument at the time, as many, Washington, D.C. was, well, maybe this was prescient. Washington, D.C. was going to become a center of corruption, and we would soon be like the monarchies. But once the Constitution was adopted, he said, it's our Constitution now. People have spoken. I'm going to go with the will of the people. And this argument says he wasn't. What happened, of course, is he died too early. He died, and the people who got to do the narrative were Jefferson and Madison, both of whom lived and so their twist on this was, here was a lazy, ingrate who opposed the Constitution, and that being his heritage. And this guy says, no, Henry was a true patriot. Once he understood what the will of the people was, he was willing to follow it, even if it was contrary to what he had thought. So it's a very good read. University of Virginia Press. I highly recommend it.
And there's
then another book.
Yes, go for it.
Another book, and you'll know this person, Rachel Martin.
Oh, that's right. She was in my same grade. We went to school together at Oakland High School in Murfreesboro, Tennessee.
And you will like this,
extremely bright.
Now, this was at my request. I don't know if you can read it, but I heard her give a speech.
I can see it. There we go.
And it's dedicated to Virginia and Rebecca's mom and dad.
Rebecca being my twin sister and our office manager.
That's right. So, A Most Tolerant Little Town is the story of desegregation in Clinton, Tennessee. Outside or near Oak Ridge, that area of the country.
Which is where Rebecca lives, and you live in Tennessee as well.
And it's a very sad, I heard her give a speech last Saturday ago, and she gave a great speech. And basically what she says is, when we think about history, we think about the Patrick Henrys of the world and the Donald Trumps.
Right.
But each of us make history in our own way, and sometimes we're heroes and sometimes we're villains. But most of the time we're both. Solzhenitsyn says something like, the line between good and evil goes through the human heart, and we have both of those qualities. And so, I can't remember which one, but you'll see here are 3 white boys who are protesting. We don't want to go to school with Negroes.
Sure.
They're outside the school. One of these was like a 16-year-old, forget his name now. He was a 16-year-old brilliant guy, had just won the state 4-H speaking competition on, the need for good citizenship. And yet he decides to drop out of school rather than attend school with African Americans. Then she has another story of a Baptist preacher who one Sunday they're doing a Bible lesson on how the Bible requires segregation. And that's what they believed.
Right.
But in the course of this, when the desegregation ruling comes through, he says, well, we have to obey the law. That's also scriptural. He ends up actually leading this group of 9, or I don't know how many were left at this time, but he ends up leading this group of African-American students into school. He's beaten up. But over the course of this, he becomes something of a hero. But and I'm not going to go through the who's. There's a school superintendent or a school principal involved. There are many people. But one of the saddest things about it is two of the heroes of this book ultimately end up committing suicide. Why? Because they're constantly harassed.
Trauma.
Clinton High School, by the way, is blown up, dynamited. And, some of them 30 years later, so maybe it was something else happened in the meantime, but her interpretation is they walked around with PTSD for 20, 30 years. And, they were heroes. They did, some of them, they did the right thing, but ultimately it became too much for them. It's a very inspiring. One of the odd things about it is if you ask most people about, if you ask them about Little Rock, Arkansas, they know about Little Rock, Arkansas.
But not
You
Clinton.
ask them about George Wallace standing in front of the door at the University of Alabama, they know about that. Most people don't know about Clinton, Tennessee. And it's been sort of, and one of the fascinating things about Martin is she was actually, I don't know if she was working on a master's here or she was working in our Al Gore Center, but she was doing, this book took about 18 years in the making. She started out by doing oral interviews with the people who had participated in this.
Wow.
And lots of them were not. And, one of the fascinating stories that I found in this book. So how many years is this? This happened in 1956, I believe. Okay. So she would have been doing research maybe 2000, somewhere along there.
Early to late 2000s.
And she tells about, she had a particularly difficult time for obvious reasons talking to some of the African Americans because it had been very traumatic for them. Imagine walking into school, nobody wants you there, and they're throwing eggs at you and tomatoes and whatever. But she tells the story of finally sort of almost bushwhacking, finding this guy and coming to his house, and he's very polite and interviews her. Very, very hot day. And she so much wants to go inside, and then she realizes he can't invite her inside because he knows about Emmett Till. And he knows how many African American men have been accused of rape or been accused of making a move on a white woman. And so almost 50 years later, there's still this, something that you and I
wouldn't think twice
about inviting an African American into our home. And many, he was not being inhospitable, is what I'm trying to say. But she realized that this, even 50 or so years later, we haven't quite gotten to where we thought we were. We still have problems. And she's a very dynamic speaker. And partly because she doesn't paint everything black and white. I mean, it's about integration. But she realizes that good people made bad decisions, and people that started out on one side ended up on another. And it makes you think. I don't think I'm ever going to be in a historical situation that big, but maybe we will be. And would we do the right thing, and would we be able to, as the situation changed, would be able to change with it in the proper way? So it's a very good book. It's published by Simon and Schuster, and I think this one is 2023. I talked to her, and she said in July, I believe, that they're going to have a paperback edition. Excellent. And this is not a terribly expensive book, but it really is the most tolerant little town. If you want to sort of get your eyes open to another era, it's very good.
Excellent. All right. Well, thank you very much to both of you. This is the Legal Weekly Wine, where we touch on the hottest legal topics of the week. I think we've hit them for this week. Thank you both for joining us. Don't forget to hit like and subscribe so that you are up to date on all of our current news and our weekly news, and so that others can see us. And also, as a law student and undergrad student, don't forget to check out thelawunscripted.com, where we do offer classes for 8 subjects of law school, including criminal law, criminal procedure, evidence, constitutional law. Dr. Vile's even included on that. We have over 50 videos and written products for you to choose among, either piecemeal, a la carte, in bundles, or an all access pass. So check that out.
And Chelsea's actually used this, right?
She
Yes.
was part
And
of
she
it.
passed the bar.
Yes, I passed the bar on the first
Post hoc
try.
ergo propter hoc, right? This must have been the reason.
You know what? I will fully attribute it to going through these hypos and the lectures with Virginia. I don't think I would have passed without it. So there's my glowing recommendation for you. You can see me struggling and like working through, commiserating with the struggle that is bar prep. So yeah, check them out.
Yeah, if you like our conversations, it's very conversational. We have lecture pieces where it's just me. We've got the conversations with Chelsea and with me, some with Dr. Weil, as well as the hypotheticals where we take a real practice question that I've created and we walk through it. What's the answer going to be? We have quite a lot of fun with it. So hopefully it's something enjoyable, something entertaining, as well as something extremely useful, where if Chelsea could pass the bar by going through the entire program, so can you. So,
oh no, wait, she probably would have passed anyway, right?
Let's not go there.
Okay.
You know what? I'm not a betting woman, but I wouldn't have put my odds on that. I think I was very lucky to have the resources in Virginia to help me through it. And so I love that we're able to share that with everyone else too.
Yeah, walk through it with us. We had a great time, as much as a good time you can have is studying for the bar. But we do put it on the videos for everyone to see, with Chelsea being completely real as where she was, what topic she was struggling with, how you walk through it, how we talk through it. Hopefully you can get some great information from that.
Is there a sample, Virginia? I should know, but you have one that somebody can look at for free and then decide whether they want to buy others or not?
So sort of. We don't have them with the actual classes that we take for the bar, but if you do the Law Unscripted podcasts, those are free, and those are solely with Chelsea and with me. And it's our conversations about what is murder, what is robbery, what happens with the jury, what's the real thing that happens with the jury. So if you want to see our conversation and the type of things that we do, go to that podcast. That is completely free. And we have at least 30 of those that are free and engaging, and you can still get information that is helpful for your law exams and your bar reviews. And if you like those, definitely then go to the full program or pieces of the program that you think that you need. For me, I would have bought property. I would have paid any money to go through property because it was such a struggle for me. But each person has their own, whether it's a specific subject, an outline that they need versus a lecture that they need, versus the entire program of 8 subjects. So thanks for the question. We hope that you enjoyed the podcast. We hope that you get some great advantage from thelawunscripted.com. And thank you both for being with me today.
Pleasure.
Of course. Glad to be here.
All right, everybody. Thank you for being with us, too. This is the hottest takes from the Legal Weekly Wine on the second week of February 2024, and we will catch you next time on the Legal Weekly Wine.